My name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to briefly discuss the victory of another law firm, this time WilmerHale versus the Trump administration. As seen in episode 17 involving law firm Jenner & Block and episode 9 involving law firm Perkins Coie, WilmerHale successfully sued President Trump over a punitive and unlawful executive order issued against the firm, which resulted in the entire executive order being judicially nullified for violating the U.S. Constitution. On May 27, 2025, the U.S. District Court for the District of Columbia ruled that President Trump's executive order number 14250, titled Addressing Risks from WilmerHale, quote, violates the firm's First, Fifth, and Sixth Amendment rights, as well as its clients' First and Sixth Amendment rights. The executive order largely tracks the executive orders issued against Perkins Coie, covered in episode 9, and Jenner & Block, covered in episode 17. On March 27, 2025, President Trump issued the now judicially nullified executive order number 14250, titled Addressing Risks from WilmerHale. The language of Section 1 of the order largely mirrors the other two executive orders against law firms that have drawn President Trump's ear. The executive order goes on to paragraph 3 of Section 1 of the order by targeting the firm specifically for its employment of former FBI Director and Special Counsel Robert Mueller. As you may recall, Special Counsel Mueller was previously appointed during the first Trump administration to investigate interference in the 2016 presidential election by Russian state actors. Paragraph 3 of Section 1 of the executive order states in language resembling President Trump's classic whining, quote, WilmerHale is also bent on employing lawyers who weaponize the prosecutorial power to upend the democratic process and distort justice. For example, WilmerHale rewarded Robert Mueller and his colleagues by welcoming them to the firm after they wielded the power of the federal government to lead one of the most partisan investigations in history. Mueller's investigation epitomizes the weaponization of government, yet WilmerHale claimed he embodies the highest value of our firm and profession. Mueller's investigation upended the lives of public servants in my administration who were summoned before, quote, prosecutors with the effect of interfering in their ability to fulfill the mandates of my first term agenda. Sounds almost straight out of Fox News or a Trump tweet. The other sections of the executive order are largely a copy and paste job from the orders against Perkins Coie and Jenner Block. Section 2 covers punitive suspensions of security clearances held by WilmerHale employees. Section 3 covers the termination of federal contracts between the federal government and the firm. Section 4 addresses the alleged racial discrimination of the firm. And Section 5 involves limiting access to federal government employees to federal government buildings. I'm going to quote from excerpts of the U.S. District Court for the District of Columbia, Judge Richard Leon's 73-page memorandum opinion that judicially nullifies and renders legally void the entire executive order. Quote, the cornerstone of the American system of justice is an independent judiciary and an independent bar willing to tackle unpopular cases, however daunting. The Founding Fathers knew this. Accordingly, they took pains to enshrine in the Constitution certain rights that would serve as the foundation for that independence. Little wonder that in the nearly 250 years since the Constitution was adopted, no executive order has been issued challenging these fundamental rights. For the reasons set forth below, I've concluded that this order must be struck down in its entirety as unconstitutional. Indeed, to rule otherwise would be unfaithful to the judgment and vision of the Founding Fathers. Judge Leon, in describing the WilmerHale law firm, stated, quote, its litigation practice has long advocated for clients and causes across the ideological spectrum. Keeping with that practice, WilmerHale has represented clients in litigation against the federal government during both Republican and Democratic administrations. Certain of WilmerHale's cases and clients have drawn the ear of President Trump. The firm's affiliation with Robert S. Mueller III has also attracted the president's displeasure. Quote, during the 2024 presidential campaign, then former President Trump threatened to, quote, go after his political opponents and warned that, quote, when I win, those people that cheated will be prosecuted to the fullest extent of the law, adding, please beware that this legal exposure extends to lawyers. After he won the 2024 election, President Trump renewed these warnings, stating that, quote, we have a lot of law firms that we're going to be going after because they were very dishonest people. President Trump followed through on these threats. On February 25th, 2025, he issued a memorandum to the heads of intelligence agencies instructing them to suspend any active security clearances held by individuals, including all partners and employees of Covington and Burlington, a law firm who assisted former special counsel Jack Smith during his time as special counsel. Jack Smith, as special counsel, had brought criminal charges against then former President Trump in 2 cases. The judge stated that one day after President Trump issued the executive order against WilmerHale, the firm filed suit alleging that the order violates the First, Fifth, and Sixth Amendments and the separation of powers of the U.S. Constitution. The judge concurred with 4 counts of the firm's complaint alleging that the executive order against WilmerHale violates the First Amendment of the U.S. Constitution. Count 1, retaliation for protected expression. Quote, WilmerHale represents a range of clients in litigation. The advocacy is unquestionably protected conduct under the First Amendment. The First Amendment guarantees the right to be free of governmental restraints on political expression, and that right is violated if the government affirmatively interferes with constitutionally protected litigation as a form of political expression. Quote, the WilmerHale order is on its face retaliation for the firm's protected speech. Indeed, Section 1 outlines the motivations of the order, including WilmerHale's pro bono practice, quote, obvious partisan representations to achieve political ends, and involvement in immigration and election litigation. The order goes on to impose a kitchen sink of severe sanctions on WilmerHale for this protected conduct. In addition to vilifying the firm, it suspends WilmerHale employees' security clearances, coerces the firm's federal contractor clients to end their engagements with the firm or face cancellation of their contracts, targets the firm for investigation into supposed racial discrimination, threatens to bar its employees from entering federal buildings or engaging with federal employees, and prohibits agencies from hiring firm employees. Taken together, the provisions constitute a staggering punishment for the firm's protected speech. The order is intended to and does in fact impede the firm's ability to effectively represent its clients. For example, WilmerHale attorneys may not be able to enter federal courthouses for trial, meet with federal regulators, or access classified materials necessary for working on national security matters. This in turn has severe economic consequences for the firm. The order shouts through a bullhorn, if you take on causes disfavored by President Trump, you will be punished. Count 2, First Amendment violation. Viewpoint discrimination and violation of the First Amendment. WilmerHale's representation of clients in litigation is speech. The order attacks the viewpoints WilmerHale expressed over the course of these representations, describing WilmerHale's work as, quote, partisan and, quote, political, and maligning WilmerHale's advocacy on behalf of causes disfavored by President Trump. Judge Leon went on, quote, President Trump can share his views freely and criticize particular beliefs, and he can do so forcefully in hopes of persuading others to follow his lead. He cannot, however, use the power of the state to punish or suppress disfavored expression. Count 3, First Amendment violation. Right to petition the government. Judge Leon went on, the First Amendment protects the right to petition the government for redress of grievances. The Supreme Court has treated lawsuits as petitions. This right to petition is integral to the democratic process. WilmerHale has both alleged and shown that the order violates the petition clause by 1, punishing the firm for its past representation of clients in litigation, and 2, undermining the firm's ability to pursue litigation in the future. The order explicitly targets WilmerHale, at least in the part for the litigation is pursued, including election and immigration lawsuits. After identifying these purportedly harmful lawsuits, the order then sanctions the firm for pursuing these cases. Count 4, First Amendment violation. Judge Leon went on, the Supreme Court has long understood as implicit in the right to engage in activities protected by the First Amendment corresponding right to associate with others. Compelled disclosure of affiliation with groups engaged in advocacy can violate this First Amendment right. WilmerHale alleges that the order compels the firm's federal contractor clients to disclose their affiliation with WilmerHale, which engages in advocacy on their behalf and on behalf of other clients. I find that this disclosure violates the First Amendment, freedom of association. Count 5 of the law firm's complaint, Judge Leon went on, quote, WilmerHale argues that neither the Constitution nor any statutory authority empowers the President to issue the order, and in fact, the order violates separation of powers by usurping judicial authority to identify and sanction abuses of the judicial process. The President, by issuing the order, is wielding his authority to punish a law firm for engaging in litigation conduct the President personally disfavors. Thus, to the extent the President does have the power to limit access to federal buildings, suspend and revoke security clearances, dictate federal hirings, and manage federal contracts, the order surpasses that authority and in fact usurps the judiciary's authority to resolve cases and sanction parties that come before the courts. The judicial power includes the inherent authority to sanction attorneys for their conduct in Article III courts. The order sanctions WilmerHale and its attorneys for their conduct before Article III courts. This encroaches on the judiciary's exclusive power to sanction attorneys. In regards to Fifth Amendment procedural due process implications of the executive order, Judge Leon states the Due Process Clause of the Fifth Amendment guarantees that the government will provide due process of law before depriving an individual of life, liberty, or property. WilmerHale alleges that the order deprives the firm and its employees of protected liberty and property interests without any meaningful process. President Trump issued the order without any due process. At its core, due process requires notice of the proposed official action and the opportunity to be heard at a meaningful time and in a meaningful manner. Defendants concede that WilmerHale has given no notice that the order was forthcoming and that WilmerHale was not given the opportunity to respond to the allegations of the order. That does not comport with due process. Both the Supreme Court and this court have recognized that the right to know the factual basis for the action and the opportunity to rebut the evidence supporting that action are essential components of due process. The order deprives the firm of its protected liberty interest in petitioning the government without notice or an opportunity to respond. Accordingly, it violates procedural due process. Judge Leon's order raises other issues involving the executive order's other violations of the Fifth Amendment and violations of the Sixth Amendment of the U.S. Constitution. Judge Leon's memorandum order concludes by stating, quote, for the reasons set forth above, I find the order is unconstitutional. The judge, in his May 28, 2025 synopsis order released today, rules, quote, the executive order 14250 issued by the President on March 27, 2025, and entitled Addressing Risks from WilmerHale is unconstitutional because it violates the First, Fifth, and Sixth Amendments of the U.S. Constitution and is therefore null and void. Keep following Executive Coup for further updates on these matters and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.